The following program is made possible in part by the Dayton Bar Association.
Federal bench since 1984, which is now, I can do that math, that's 31 years, and was a municipal judge and worked for the firm of Smith & Schnocky, which doesn't exist anymore, but it was absorbed into Thompson Hine, one of the fine firms in the country. Let me ask you, we've talked a little bit about Obergefell. What are some of the things? The court's starting a new session.
Right.
Pretty soon. I don't know the
Today.
exact. Today. Okay. Well, there you go. Perfect topic. What are some of the topics that are of interest to the public in this session?
I think I'm not well versed on what this term has already agreed to here. I think there's another Affordable Care Act case already pending. There is, I believe there's an affirmative action in higher education case pending. Given the area of law that I work in most of the time, which is the death penalty, we would expect the court to have a number of death penalty cases this term. Probably cases that they haven't decided to hear yet, because those come sometimes at the last minute before executions. So they're not queued up yet, but we can expect, I think, some death penalty stuff this term. They had a big death penalty case right at the end of the term, within a week of the time this same-sex marriage case was decided.
Recently, I don't remember the name of it, but not recently, it was just last week, a woman was executed, I believe, in
Georgia.
In Georgia.
Right.
I was going to say Texas. Why do I say that? Because most of the cases come from Texas, I guess. And there was a large groundswell of opinion on that, mostly on the side of not executing the woman. And tell me if I'm wrong on this fact situation, but it seemed like kind of a garden variety murder where the woman asked a boyfriend, maybe, to murder her husband and cover it up or something. And then, like all murder cases, the boyfriend made his plea bargain not to be electrocuted by ratting out the person who planned
it. Wouldn't be electrocution. Nobody's electrocuting.
Well, I call it that. What do they do down there?
Lethal injection.
Lethal injection.
Every state that's doing executions is doing lethal injection.
When I first started doing them, they were electrocution, and I remember part of the defense argument was to show a picture of a person getting electrocuted, which didn't seem to deter a lot of juries, but
we still have a number of cases pending where, and that's how long they take to get through the system, a number of cases pending where the death warrant reads electrocution.
Well, that case was 18 years old.
That would not be, that's not unusual. I've got cases that are much older than that.
And are we gravitating, do you think, I mean, the courts administer the law as it is given through precedent, of course. But there's got to be some emotion on the bench also about whether we should be doing this. The prosecutor's argument seems to be if you didn't at least have it there wouldn't be any deterrent at all because people would know they're not, you can't sum to Elba, I guess.
Right.
So it seems to me there's a gravitation towards maybe eliminating it, but maybe it's not going fast enough.
Well, and if I were, which I am not, but if I were an advocate for abolition, that'd be the same argument I'd make to the United States Supreme Court, which is the argument that was made in this same-sex marriage case. It's going, but it's not going fast enough. But so far that hasn't gained much traction. There have been a couple of Supreme Court justices who've been converted to abolition. Thurgood Marshall, William Brennan, most recently, I want to say, and I can't say the name, I think Justice Stevens got pretty close to that position before he retired. But so far, the court is not there. They were there in 1972. They backed off in 1976, and they have refused to go back.
Does a lot of that have to do with the personalities of the persons on the court, the justices on the court, and the groupings?
I think it does. The decision that came down at the end of the term, the Glossop case, it was a technical case about how much of one particular drug you have to give somebody to knock them out. But Justice Breyer wrote a strong dissent in which he said, you know, we keep tinkering with the machinery of death. It's time to think again the fundamental question about whether we ought to be doing executions at all. Seemed to be inviting somebody to bring a case to the court that would make the fundamental challenge.
Do you believe that the defense of the abolition has to move in those directions, taking into effect that the executions have to be humane, which I guess hanging wasn't humane enough, and then the electrocutions weren't humane enough, and maybe the shootings, the firing squads weren't humane enough, as a way to get closer to abolishing it altogether, in that there is no humane way to just take somebody's life?
I think that's the argument that if the Supreme Court were going to go that way, that's the argument that ought to be made to them, and the one that they would accept. They haven't gotten there yet. They've never declared electrocution to be inhumane, or the firing squad for that matter. Interestingly enough, the case they had at the end of the term, they said, if you come to us with a case that says this particular drug causes too much pain or doesn't execute fast enough, you have to suggest an alternative that would be less painful. And we're sort of waiting to see what will happen with that. The one method of execution we've never done in this country that is completely painless, very fast, is the guillotine. But I can't imagine any American legislature.
Madame Defarge.
Yeah, right. I can't imagine any American legislature, much less the Supreme Court, going along with that. So painless isn't enough. Can't be too gruesome either.
Well,
is my guess.
I'm guessing that modern civilized society doesn't like dismembering of any parts.
Right.
They don't mind shooting you, or I don't mean you, of course, but shooting the perpetrator, or I guess if you hang them, they're still intact.
We stopped doing executions in public well over 100 years ago. It's been a long time. In fact, to our national shame, we've had public lynchings after we had public executions. The one sort of famous firing squad execution, the Gary Gilmore case,
right,
which was the first one after the moratorium ended, was a firing squad case.
Well, he had an election, didn't he? Whether he wanted to be electrocuted or shot,
right,
and he picked the firing squad.
That's right. That's right.
And it was pretty quick and painless, I guess. you might need a doctor to come in and explain which is more painless or less painless, or how long it takes, or
There's
something
a
like that.
lot of medical testimony in these cases right now. And the thing that's making it hard to do executions is that the drug manufacturers, the public manufacturers of drugs that have been traditionally used for executions, are refusing to sell them for that purpose.
Yeah, the American.
Foreign as well.
Foreign as well.
Yeah.
I hear at times that they say, "Well, we can't do it because we've run out of the drug." How do you? Maybe if I did a little research, I'd know. But how do you run out of a drug where they're basically manufactured? You run out.
Because you run out because you used up what you had.
Right. And there's no
There
call to make.
There may
more.
be expiration dates, but you can't buy it again because the drug manufacturer says, "I won't sell it to you for that purpose."
And they don't have an inventory, I guess.
Right.
Okay.
I don't know whether the inventory is such that you can't keep it because of expiration dates. I don't know.
Maybe it wouldn't work.
Yeah.
Maybe not effective or something. Now, I don't know if you want to talk about this, but you did mention that part of your job here in the district court is to oversee the death penalty cases after the trials and appeals.
Right, exactly.
Would that be something you'd like to tell the public about, or what the procedure is for those, and how, if it's all over, why are we doing it again? Habeas cases.
Corpus. Yeah. An important right written into the United States Constitution that sort of rejuvenated in the 60s by the Warren Court that says you've got a right to have a federal court say whether your case was dealt with constitutionally in the state courts. And that applies whether it's death penalty or non-death penalty. And right now I spend almost all my time doing those kinds of cases. Only can review the cases for whether or not they were done constitutionally, but as I think most people know, the Warren Court expanded the constitutional criminal rights enormously. So everybody knows about Miranda, but that's just probably the most famous.
Yeah.
There are literally thousands of cases that have expanded or delineated those rights, and that's what we do. We decide whether or not the state courts got it right or not.
Our floor director tells me that we actually have a phone call. Not actually, maybe there's a line of them, but anyway, we do have one.
Excellent.
So we can take that call at this point. Good evening, you are in You and the Law.
Hello, do I need to give my name?
No, you don't have to. Where are you calling from?
I'm in Dayton, Ohio.
Okay. Well, you can keep your anonymity if you want, but we would like to hear your question.
My question is concerning a case that a young man was charged with gross sexual imposition. This happened about 18 years ago. That person is still suffering from, as it relates to housing. He can't get housing. He can't get housing because that gross sexual imposition is a felony. He was forced to take a plea bargain at the time. And why does the law look at a case such as that to where he cannot have it expunged, or that's his understanding, he can't have it expunged? It has been over 20 years because this individual is in his 40s now. This happened when he was 18 or 19 years old. And I'm wanting to get the law on that. Why is it so handled so?
Do you think that?
Because there are murderers that go to jail, get out, and they don't have the same.
Okay, well, yeah, that's a good point. And you're wondering if why wouldn't the Constitution maybe protect him after he served his punishment?
Correct.
Right. Judge, would you like to address
I mean,
that?
he's suffering in such a way now. He's older, and to not be able to find a decent job looks like his rights are being violated as a result of this felony. The felony is what the question really is. Why is it this particular felony cannot be lifted?
Can I ask you, if you know the information, was this person originally charged with a more serious crime than
Yes.
the one he pled to?
Yes, he was charged with rape,
all right.
and he pleaded to the gross
right.
sexual imposition because the lawyer said that otherwise he would have to, he would get a stiff sentence.
If he was convicted of the higher charge, he'd get...
Of the rape.
Okay, all right.
He would get, like 25 years or something of that sort.
But nonetheless, he and you are concerned with the thing just hanging over him.
Just hanging over him.
Right.
And
I assume he's not...
He can't find a decent job because of the felony.
And not committed.
The felony on his record, and, of course, when he goes to apply, companies
Right.
check the criminal background record.
But has not committed more crimes.
Has been past 7 years. I thought that was really after everything fell off your record after 7 years, even 10 years. It has been longer than that, and I don't know if it's because he has not pursued getting this information expunged. I don't really know.
Okay. Well, let's have Judge Mers weigh in on this. And
First, it's a superb question. Second of all, it points to a problem that's not unique to the person you're mentioning. We've got most people who are convicted of felonies end up coming back to the community from which they were sentenced, and we've not done a good job of reintegrating them into the community. And if they're not reintegrated into the community, experience tells us they're liable to fall, glad he hasn't, but many people do fall back into their old ways. So there's a second aspect to it, and I'm not sure about, given the time of the conviction, but a person convicted of gross sexual imposition today would get, in addition to whatever jail time, they would be required to register as a sex offender. That not only makes it hard for them to get a job, it makes it hard for them to find a place to live. My personal opinion, it's one for the legislature to deal with, but my personal opinion is that we've become unbalanced. We have awful lot of people in prison right now, far more than at any time in the past. Those people are going to come out, and we need better strategies for reintegrating them, making them productive members of the community again. But to answer your specific question, I don't know whether the felony conviction could be expunged. Under Ohio law, that's a tough process. And the federal law, the federal Constitution, does not presently have any protection for your right to have your reputation restored. That's another place the Supreme Court could go, I suppose, but they haven't gone there yet.
Does that answer your question, or at least address it?
Speaking with a lawyer?
I'm sorry, what did you say?
Am I speaking to a lawyer?
Both of us are, yes.
Okay. I guess I don't know who I'm talking to.
Are you watching us on TV, or?
I am, but I muted it because I didn't.
Oh, okay. Yes, you are.
Interview. I can hear now. Okay.
All right. So Judge Mers obviously is a lawyer, and I am also, even though I'm the host of this program. So what follow-up are you addressing then, if any? Are you still there? Okay, I think our caller is hung up. I didn't know whether that meant maybe that's no help or something like that. And some things aren't. And I think your answer basically was the courts are the last resort for determining whether what the legislature has done in enacting these laws is constitutional, whether they are valid laws, and there might not be an answer to her question of getting relief.
Well, the Supreme Court's not been very liberal in extending the cruel and unusual punishment clause to protect people from either certain amounts of prison time or the civil consequences of prison time. The cruel and unusual punishment clause has tended to be limited to use in the death penalty area.
Right. Okay. Let me break just for a moment. We have approximately 18 minutes left. You're watching You and the Law here on DATV. We are talking about substantive due process. Maybe that's too cumbersome for our
fundamental rights.
Fundamental rights is what we're talking about, the Constitution and how it affects you, the viewing public. And we've got Judge Merz from the District Court here in Dayton, Ohio, serving. How big does it serve? I don't know. There's lots of counties here.
I can't tell you right off the bat. About 12.
We're kind of in the niche between Cincinnati and Columbus, right? And Judge Merz right now is specializing in death penalty habeas corpus cases, and we were talking about that a little earlier. And the viewing public probably is interested in, why are we doing this all over again? Why haven't we just either executed them or put them in, or her, into some sort of a prison setting where they aren't going to come out and do it again type of thing? And what is the, maybe you don't want to answer me, but what is the percentage of these things that are successful?
Of the...
And what would happen if you as judge, and then it was sustained all the way up, said this man or woman's rights were violated, maybe to fair trial or fair process at the appellate court?
Well, sometimes we think that their rights were violated, and the Court of Appeals disagrees with us.
Sure.
Got one pending like that right now in the Sixth Circuit. But if we're sustained, what happens is the person gets a new trial. Mm-hmm. Now, 20, 25 years after the fact, it may be pretty hard to retry them. Often, we've had a number of cases where we have said their rights were violated, and the state has decided to accept a lesser sentence.
Mm-hmm. Time served or something.
Well, never time served, but a life with parole eligibility at 20 years or 30 years. That's happened with a number of our cases.
And
we've never had one retried yet.
That's because they take so long, probably, right? And how many cases are there right now under your jurisdiction?
46.
That's a lot.
Southern District of Ohio has the second largest pending death penalty habeas corpus docket in the country, second only to, I believe, Eastern California.
Now, is this related in any way to the Innocence Project? And of course, that's a big movement now, and I think they're centered in Cincinnati in our district.
That's right.
And DNA, and are they interrelated in any way? I know that some of the cases that I have been related to or been involved in, we get calls from Project Innocence and saying maybe you won't be successful there, but maybe the person shouldn't be here in the first place.
Well, we've had a number of cases in which DNA evidence has been either important or argued to be important. We had one case, a man who now has an execution date, where he had DNA evidence was against him. The case had been around long enough that he asked for a new test because their testing methods have become more sophisticated. Came back very unhelpful to him. The last execution in Ohio, Dennis McGuire, was my case. Mr. McGuire asked for more DNA testing, which we got for him. That was also not helpful to him. We have a couple of cases now that have been sent back to the state courts under the state's DNA testing, post-conviction DNA testing program, where there's DNA testing going on, but we don't have the results of the state court procedure yet. Every time I've been asked to facilitate a DNA test, we've done it. We have the budget to do it because I think rightly the public perceives that that's pretty good evidence one way or the other. So we do it every time we can. But I've not had any of my cases, and I've had over 60 of them in the last 20 years. I've not had any of them where the DNA testing exonerated a person. If you read the exoneration cases, and there have been hundreds of them, most often they're rape cases. That's the situation where you're most likely to have a sample retained over a long period of time. Often they're questions of whether the eyewitness identification was any good or not. And of course the DNA, in many cases, exonerates one guy, but then puts another guy behind bars. So in the murder cases, it just tends not to be that critical.
I guess I'm just asking for your own opinion, but if you actually, say, committed the crime, and there might be some other avenues to get exonerated, well, maybe not get exonerated, but at least get a new trial or something, aren't you kind of sticking your feet into the fire by asking for a DNA test, or?
If you did it and you've got another way out.
I guess that's what I'm asking.
Yeah, exactly right. If you did it and you've got another way out, I'd stay away from the DNA, because if they've got any samples, that's going to be the end of your case. You can have all kinds of good technical defenses, but whether or not judges look favorably on them, whether they find that the other errors were prejudicial or not, may depend upon how solid the case is against you. And the DNA, if the DNA is bad, the DNA can make it pretty solid.
Right. Okay. We've got 10, 11 minutes left, and before the program, we talked a little bit about direction of the court due to the personalities of the members of the court. We won't talk about the ones in the district here, but on the Supreme Court, it's kind of fascinating. And you had some insights on that. I don't know if you'd like to share some. It's probably not enough time to get everybody in.
I think it is fascinating. In this Obergefell case, the same-sex marriage case, Justice Scalia makes a point of saying how unrepresentative the court is. Well, this is probably the least representative Supreme Court we have ever had. There are 6 Harvard lawyers on the
Didn't they have something back when President Nixon was trying to put somebody on the court, and they said, we need somebody average?
Yeah, mediocre. I think he nominated somebody that
for the
people called
man.
Mediocre, and Senator Ruska said the mediocre need to be represented too. And of course, Justice Scalia's perspective is that there are no mediocre people on the court now, but there are no Protestants. Imagine what the founders would say if they discovered that the Supreme Court was made up of 6 Catholics and 3 Jews. Scalia also makes the point that 4 of the current justices were born in New York City. And he says none of that should matter because we're all picked for our skill. But that's, I think that's a pious myth.
Yeah. Well, they're there for their scholarly mean, I think, rather than whether they've worked on the docks or been in the Navy or
Well,
something
I
like
think
that.
that's right.
But does that convince the public or the media, or is it just people trying to cause trouble?
I don't think it ought to convince the media or the public. One thing that the public should not get confused about is believing that you can control the court by picking the right presidential candidate. Justice Kennedy, who wrote this same-sex marriage opinion and who wrote the decision 12 years ago in the Lawrence v. Texas case that said consenting homosexual conduct is constitutionally protected, marriage or no marriage, is a Reagan appointee, is a Roman Catholic, and he was vetted by the administration as a social conservative. So as a guy who would vote to overturn Roe versus Wade, and he certainly has not done any of those things.
Why does, okay, and I'm diverting a second, but Roe versus Wade was 1972, wasn't it?
Early 73, I
73.
think. 72 term.
Why is there such conflagration over trying to get what they say is the right right case back into the court, because it needs to be overturned? If it's overturned, where are we going? What are we going back to? Is this Planned Parenthood thing trying to eliminate that?
It has become since Roe versus Wade came down, it's become a kind of lightning rod for people, and I don't know where we would go if Roe versus Wade were overturned. We don't. I mean, I think for example, the last two clinics in Ohio that provide abortions are only open right now on sufferance of a stay order. They're due to be closed because of not complying with state regulation. There's not a whole lot of abortion available. I don't know whether there's very much illegal abortion of the sort that was the rallying cry before Roe. We got to get rid of that. There just wasn't a movement before Roe versus Wade. To the extent that movement is strongly Roman Catholic, it has missed the point of recent papal teaching, which is got to get rid of the death penalty too.
Well, yeah, they do seem to be interrelated, but they're the same but different, right?
Well, that's the argument that's made by some, but the recent papal teaching has been right to life from conception to natural death, and that includes no capital punishment.
And I suppose the argument would be that babies are just innocent, and,
right,
and murderers aren't.
People on death row are definitely not
innocent,
no.
Unless they're wrongfully there.
Right,
of course.
Right.
Got to get that in too. So will it come back, do you think?
No.
I mean, will it come back to the Supreme Court?
I don't have a crystal ball on that one. It's not the kind of case that I watch, and
no, because they just pop up out of nowhere, don't they?
Yeah, and the court doesn't have to. The Supreme Court never has to take a case. People should realize that. They can always put it off or decline jurisdiction, and you can't force them to take one.
And I don't think the public really realizes that. I think everybody who is supporting someone who is either loses a case, criminally or civilly, says, well, we're going to the highest court in the land. Tell us why we can't do that.
Well, William Howard Taft is the three-word answer.
Okay.
God rest his soul. When he was Chief Justice, the only man who's been Chief Justice and President, when he was Chief Justice, he was very concerned about the administration of the courts and the fact that at that time, the Supreme Court docket was overwhelmed with unimportant cases, cases important to the litigants, but not important to the broad scope of the law. And it was Taft who convinced the Congress to limit the mandatory jurisdiction of the Supreme Court, and that that trend has continued. There have been 3 or 4 further restrictions of the mandatory cases. I think the only mandatory thing that they have to consider today.
Well, they don't all have to agree to take it, though. You don't have to have a unanimous
you have
decision.
to have 4.
4 out of the 9.
But the other 5 can prevent a decision by dismissing the writ as improvidently granted. So the majority can always avoid the decision.
And that's why we need to go to law school.
Amen.
Okay. We have about 4 minutes left. And in those 4 minutes, I'd like to ask if you'd like to opine about any of the status of where we're going in the law, or is the Constitution expanding or contracting?
Well, the one point I really would like to emphasize with folks is this fundamental rights stuff can come back to bite you. Back when I was in law school, I expect when you were in law school, we learned that the economy needed to be regulated, and the government had a right to regulate the economy. And there are a lot of people today who want the economy to be less regulated than it is. I happen to think that a lot of those folks are the ones who brought us to the Great Recession in 2008. We were only one vote away from losing the most important of the capstone of the economic regulations cases, and that's a case called Wickard versus Filburn, which arose right here in Montgomery County. Farmer Filburn planted more corn than the Roosevelt administration said he should. His farm is right where the Salem Mall was. That's where his farm was. And the Supreme Court said, no, that's preventing him from planting corn that he was going to feed to his own cows was still regulation of commerce, because what he raised at home, he didn't have to buy. Mm-hmm. And we came within one vote of losing Wickard in the Obamacare case. The economic libertarians are very upset with Chief Justice Roberts that he voted to keep that precedent. And there's been some agitation among Republican presidential candidates that's the focus. We've got to get one more vote that will go against where Roberts was. He's come under a lot of attack. Apparently that's what you have to do to be a bona fide Republican presidential candidate, is attack the Chief Justice on economics.
Do you think that Chief Justice Roberts, even though pretty hardcore conservative, I've heard, might be taking his job really seriously and siding with what's going to be good for the country and not just for political reasons?
And I think he's been a wonderful compromise builder. Mm-hmm. I happen to agree with his vote on the Affordable Care Act, because I agree with the policy and I agree with the law that I think the precedent that he relied on is appropriate. Maybe that's just because that's the way I was brought up in law school. Yeah. But a lot of people have health insurance today who didn't have it.
Right. Can't do away with that. Right. Well, I think we've run out of show. I'm looking at our clock here. It's been great having you here, Judge Merz. To you viewers out there, this has been a production of You and the Law, and we've been talking about substantive due process tonight with Honorable Judge Michael R. Merz from the District Court. I want to thank all the volunteers who have made this program possible, and for those who called in. We get more than one call.
I don't think so.
We thank you and hope you'll keep watching You and the Law. I've been your producer and host. I'm Mike Monda. Thank you for joining us. See you again. Good night.